26. We're now going to turn to H222, and we're going to be starting. I'm going to be starting by turning this over actually to Ken to kind of run this because I have another meeting that I have to go to. So I'm sorry, I'll have to catch up on the testimony later. But there's your list. And over to you, Ken. Thank you very much. Don't run the committee into the ground.
Just got to catch up here. Who we got first? Thank Todd.
Todd here.
Hi, Todd.
Representative Guston, how you doing?
Good. How are you?
Thank you.
Sit there and introduce yourself. I think you know how things go.
Do my best.
Ah,
For the record, For the record, Todd Delos, Assistant Attorney General with the Attorney General's Office. Having understood the testimony thus far on H222 and some of the revisions that have come out recently, we continue to strongly support the bill and the addition of domestic violence accountability programming as part of a relief from abuse order, pre-adjudication of any potential criminal charges underlying the relief from abuse order request. I'm happy to speak about that component of H222 Section 1 and also any thoughts we've got on the additional sections recently added in draft 1.1, depending on what the committee is most interested in. I will say, as to the addition of domestic violence accountability programming to relief from abuse orders, I understand there are concerns around what happens when an individual may undertake accountability programming and potential criminal liability or increased criminal liability that could arise out of that. I'll be clear that Assistant Attorney General Carolyn Hansen is the expert in our office on this. So I will provide my understanding of it, but more than happy to get Carolyn in here if that's helpful down the road, and certainly also defer to folks at the network who have very deep and full knowledge of how DVAP or Domestic Violence Accountability Program works in the state. So very quickly, as I understand it, DVAP programming does not require an admission of facts per se within the programming. I think there may, I've just learned from Rep. Goodnow that may not be consistent across the state, and I think that's something that's worth further investigation. But my understanding of DVAP programming is it's different than, say, accountability program that occurs in the Department of Corrections environment where admission of conduct is vitally important to the accountability and rehabilitation programming. Under DVAP programming, it's much more about engagement in relationship improvement and less about the specific facts that may give rise to criminal charges. It's also really important to note, and that's not particularly different than some of the other pre-charge or pre-trial programming we see, whether it be substance use programming or otherwise, where there could certainly be criminal conduct involved in the rehabilitative process, and someone might speak about it, but engaging in the process of rehabilitation inherently doesn't require an admission of guilt to be successful in the program. Beyond that, I would also say there are plenty of instances where individuals without criminal charges are referred to domestic violence accountability programming. That happens from DCF, that happens elsewhere as well. And certainly not everyone who is potentially subject to a relief from abuse order necessarily would have criminal charges arising out of the same circumstances or facts. And in fact, the hope would be in a lot of cases that there could be resolution absent criminal prosecution, right? And that's certainly what we have heard in the Domestic Violence Fatality Review Commission recommended in their report, that it was survivors who were requesting this additional statement. And again, it exists already. I should have started there. The ability for a court to impose this program already exists in the law. This is simply making it clear and express in statute that courts can impose this program. And again, I would defer to the network on this, but my understanding is it is the requester, the survivor, the victim, who can request any number of things. And then the court has discretion about whether or not they impose that programming as part of the final order. So for all those reasons, we continue to support it. We think it's an important tool. And certainly if accountability programming cuts back on any recidivism and helps unify a domestic relationship or at least prevent future domestic violence circumstances, that is in the public good and the public safety good overall. So I'll pause there, Mr. Chair, and see if there are any questions.
Any questions? Well, that was quick. I don't know who's first, but whoever wants to.
Okay. I apologize. I'm getting oriented to all of this. So we're talking about H 222, and you're saying you support that. I just know that we also have the amendment. Have you spoken to that as well? And that,
I'm ready to when
Okay.
you'd like me to. I was starting on section 1 and I'm happy to talk.
great. I just want to make sure that we have a full picture of it. So great. So I will wait.
My question is about this section. So you just said that, or rather about something you just said, but you just said that we already have the ability to impose programming. I don't think if that exists in law currently. Can you say a little more about that or where it is, just for a reference?
There is no prohibition on a court imposing an accountability program. And the goal of this addition is simply to make it clear to a survivor that they can request that relief, make it clear to a court that they can impose that requirement as part of an offense.
Okay, so there's no prohibition, and this is sort of the affirmative or explicit.
Statement.
Yeah.
You can impose it as a mandate.
They can, as I understand it, a court could currently choose to impose it as a mandate as part of the relief from abuse order. This addition simply makes it clear that a court, it basically makes it express that this is an option for a court, as opposed to a judge just knowing this is another element I could add to this.
Where is that?
So I think what you're asking is a statement about the absence of a statement. Right. The goal is to add it to make it clear to the court that it is available. There's no prohibition currently in law that it cannot be added. Does that?
I mean, I feel like the plain language of 15 VSA 1103 unamended under subsection C2, the court may include the following. They was not A through H. And we would amend to include I. So is your sort of position that that's just some they can include and they can include anything else?
Yes. That my understanding is that this is a non-exclusive. Well, and it's also not an exclusive list. It's not saying these are the only elements that can be included in it.
Does that ever happen?
I'm certainly happy to get more information on that, but my understanding is this is a change within the last, I've looked at other folks in the room who know this history better, but that was a shift as accountability programming stopped requiring admissions of guilt, but that enabled this to be included. And this is simply an express statement that it should be included.
Sorry, Karen.
That's my question.
Can interrupt any.
So I was going to use a Latin phrase, but I'm not.
Anyone else?
Well, sure, I'll ask, but it might be your question. I was just gonna ask if you have any thoughts on, adding language that would make it clear that, even though well, I think it's fair to say, it sounds like most programs don't, require or even involve an admission of guilt. Do you think that it would be helpful to add language that would specify that any information shared over the course of this programming could not be used against a defendant in a parallel criminal proceeding?
Without seeing specific language, it's tough to completely opine. I think something along the lines of what happens in diversion would make some sense here, but I would want to make sure that did not somehow sweep into other statements that may be vital to criminal prosecution here. Right. If it's what we don't want to do is say you said it here and therefore it can't be used anywhere. We want it to be clear that it sounds like what the recommendation would be. Statements made within the context of the programming could not be otherwise used. And, we would certainly be interested in taking a look at what language would be around that. But as a concept similar to diversion, we can understand that. I just wouldn't want some kind of immunity to attach.
Yeah. Gotcha, thank you.
The difference, I don't see it in anything, well, maybe a little bit like diversion, but mostly not because there, there's a better outcome in taking diversion. It's offered to the defendant. And you don't have to take diversion.
Yeah. Whereas this is, you mean, and this is mandated.
That's my point.
Yeah. Yes, and I mean, this is a policy question for the committee. It sounds like in that circumstance, because it's a requirement, perhaps protecting the individual who's the subject of the order further might make sense. As opposed to incentivizing it through
Well, they
diversion.
do that through the conditions.
That's true too.
This sounds more like a sentence of those. It has a strict number of hours that they have to complete and take out of their day and do.
Yeah, and I think what I would add is that this is a final order that comes after a contested hearing.
Yeah.
So there's,
Non-criminal.
Mhm. And there is, I mean, to get philosophical about it, there's less of a liberty interest here than there would be in a criminal proceeding. And I think here, again, the goal is, and I would leave it to the network to speak about this. The goal is to hopefully enable either reunification or prevention of recidivism through engagement in programming outside the punitive criminal process.
Well, with that said, though, there's a lesser burden of proof too before you impose.
Sure. Yeah. And that exists already in RFAs, right? I mean, that's going to
Right.
prevent
I
where
agree,
you can go.
But there's no, like, you have to comply. It's like a condition, set of conditions of release, but there's not necessarily any program.
Currently. And again, it's an option that the court can choose to impose. And I think that would be arguably part of a hearing and part of a conversation. And hopefully it would be willing programming, but we've certainly heard from folks that they're worried about it.
Just thinking about it constitutionally. 100%. I mean, it sounds like a sentence. Even though it's not. I understand the point. Most of these things come post adjudication.
Yeah.
Not pre-civil hearing or.
Yeah, I guess I would have to think further about other analogies that exist currently. I think they do exist in the child custody space. I think they exist again in certain pretrial conditions that occur around. Yeah, I mean, that's the diversionary space, which again, I understand that's a voluntary acceptance, but I think there are elements here that are analogous.
No, set down.
No.
Ian,
No, that's good.
anyone? No good?
So I'll just go to Representative Dolan's request. We don't have
The
it.
amendment,
Sorry,
correct?
the amendment. Yes, thank you, Chair.
Thank you.
So this is the amendment draft 1.1, the new section 2 and the new sections 3 and 4, which focus on surveillance and specifically GPS and vehicle surveillance. And I think there's been some testimony in that. Without wading too far into it, we are comfortable with the amendment as it stands. And I think they're, generally speaking, we support the concept of expanding this. Broadly. I don't know if there are specific questions you had, Representative.
I just wanted to make sure that
Yeah.
you knew that that was now being added to this and that you support it. That's great to hear.
Ian,
Beyond the surveillance, the section 4, use of the vehicle.
Yeah.
Thoughts on that?
I think we have potential edits to offer on it, but I don't think they're material to the policy question here about expanding access to use of a vehicle. I think one important thing to note here is, there's already, and I think this is applicable. I'm a little out over my skis on this particular one, so I'm going to limit how far I go. But in this instance, I think you've already have to demonstrate that you've suffered abuse before you get to the point of requesting a vehicle under 1111. I think that's accurate, but I'm glancing over. Yeah. So because there is that additional step, we're comfortable with how the language works.
good? Anyone else? Guess you're all thought seat.
Happy to move on, provided for the judge.
Yes. Ready, Judge? That's only. By the way, I've already heard one policy this morning.
Policy matter.
More
Oh, boy.
policy. Good morning, Tom Zone, Chief Superior Judge.
Morning.
I apologize, I was downstairs in Senate Judiciary. They were supposed to let you know. Oh, good. All right, thank you.
You're right on time.
We delayed.
So I have taken a look at H 222 as well as the amendments. Where would you like me to start? What's best?
I think I'd start on H 222 and then go to the amendment.
All right.
Sound right?
So I would like to just step forth about Vermont's abuse prevention statute. This addresses what's happening within our statute. The Vermont Supreme Court has written that our statute is designed to provide immediate relief to victims of domestic violence. The statute focuses on fast, temporary relief to family members in immediate danger, rather than on resolution of the parties' claims regarding custody support or marital property. This goal is accomplished in part by providing inexpensive and uncomplicated proceedings that allow an abused family member to obtain immediate relief without the need for counsel, advanced pleadings, or a full-blown hearing. When the court has a hearing, the court shall make such orders as it deems necessary to protect the plaintiff or the children or both, if the court finds that defendant has abused the plaintiff and that there is a danger of further abuse. Hearings in these proceedings, I know a number of you have actually gone and watched. They're short. They're based on limited information, and they're also often based upon the default of the defendant. When the defendant doesn't show up and the plaintiff may be there, the plaintiff pursues an order and is granted one at times. The focus is on the needs of the victim and or children involved for safety. It's the victim's case as a civil case, and it is the victim's order. The order generally contains prohibitions. You shall not do this. You shall not come within X feet. Very clear, unmistakable. Everyone knows what you are not allowed to do. Violation is a crime. The new legislation shifts that from what is a prohibition to an affirmative obligation. And while there are affirmative obligations for limited child support and other aspects, this is a shift. That is a policy decision for the legislature. This shift goes from immediate protection and what's necessary to, I heard testimony yesterday about rehabilitation and accountability. That's not the single focus. Now, obviously, if an individual is a risk of harm to someone, there's a final order and they take a program that helps them not take further abusive action in the future, that does protect the victim. But the focus of these cases is on the victim and what they need and not on the rehabilitation of the defendant. It is a policy decision that will have impact on the courts. If the legislature concludes that this is a policy to go forward on, there will be more hearings. The hearings that we currently have that are currently default may have individuals understanding that this is the type of provision that may come in. They may have an understanding as to what it would require, and they might come and contest the actual order that they otherwise would have let go into effect. So there will be impacts on the courts with hearings, depending on how you structure the compliance aspect. There will be either impacts that we can handle with minimal budget and additional staffing resources, or impacts that would require a lot more budget and staffing resources. And the reason I say on how it's structured is because the idea of this being offered as an option for judges and imposed is a policy decision. A policy tells us what. The procedure tells us how. And so we need to understand going forward that if you adopt the policy, what is the how? How do we go forward on this? What does the procedure look like? We know what the procedure looks like for the RFAs now, but this is something different. Again, it's taking us into the rehabilitation side. The statute does not include a proposed procedure for how things are to work. Who monitors compliance? And what the process looks like is necessary to establish what the costs and resources would be on the courts and the other entities that would be involved in the procedures. Courts do not monitor compliance. We decide the issues that surround compliance that are brought to the courts. If there's alleged to be a violation, someone says, here's an allegation. If it's a civil case, they could file a motion for contempt and the court will decide it. They bring their evidence to the court. The court hears the evidence from both parties and makes a decision. We don't tell them what evidence to bring. We don't subpoena witnesses for them. We don't come in and say, we're going to ask all the questions here today. We're doing this. It's their case. When you look at the issue of DV programming, where do we most often see it? In Department of Corrections. And I'm aware that the proposal that I heard is that the individuals who would go through any programming ordered by the courts would go to the current DV programs that are run by the Department of Corrections. Now, I will leave the department to speak for itself as to whether it believes that existing funding can absorb what I think Ms. Holter said was 300 potential cases yesterday. Did I get that right?
Yep, that's my knack in math.
That's up to whether they think they can absorb that. But when a court looks at the procedures for ordering those types of programs in the criminal context, judges don't generally say, you're going to take this exact program because I am deciding that's what you need. What we generally do is have the Department of Corrections do an assessment and then decide what's going to happen and monitor it. DOC monitors the programs, state's attorneys keep an eye on it, and that process, if there's a violation or someone doesn't complete it, someone doesn't comply, then what happens is they let the court know and we have hearings. Again, someone needs to initiate that and bring the matter before the court. Also, when we look at the procedure, we have to keep in mind that the violation of a relief from abuse order is a crime. So if someone does not do what if a judge says you need to do this program within X amount of time and someone does not, they've committed a crime. And when they come into court, if we have a hearing to decide to see what's going on, they have to be told they have a Fifth Amendment right. They have to also be told they have a right to counsel. Are we going to be supplying counsel to them at that time, given the interest at stake? Civil contempt is also an option. But civil contempt would be, well, we need you to do this. And civil contempt is viewed as, we'll call it coercive. We're trying to get somebody to do something they need to. If you have someone come to court and they say, well, I haven't done it yet. First of all, they just admitted to a crime, so they can be charged. But let's assume that we get beyond that and the judge says, okay, well, I really want you to do this. You need to do this. And I'll give you some more time. Well, and the person doesn't do it again. Well, the judge can say, well, I'm going to hold you in contempt, but civil contempt is to coerce them to do something. We can impose a financial penalty and say, well, here's a financial hit. We've all heard about, well, someone's being put in jail for contempt of court. But when you put someone in jail for civil contempt, the expression is they have to hold the keys to the jail cell. In other words, they have to have the ability to take the steps immediately to get out. If you say, well, I'm putting you in jail for civil contempt because you haven't done a 26-week program, well, they're not going to be able to do the 26-week program to get out because they're in jail. And so that remedy for civil contempt doesn't work very well. So really, the remedy here is much like in a Department of Corrections situation. If you have somebody who's not doing a program they're supposed to do, DOC will try to hint to them to do things. But when all is said and done, the mechanism is you're getting charged with a violation of probation and the court's going to address it.
If they're holding the keys, they could say, well, then I'm going to participate, and you could let them out. If they don't show, then they could go back again, like that.
Until when? And that's the
Right,
problem.
okay, yeah.
Exactly. You are correct, but where does it stop? There's also case law that has said that if someone has shown that by holding them in jail, it's not going to change what they're doing, at some point it becomes punitive, and civil contempt cannot be used as a punitive measure. So when we look at the procedure, whatever the legislature decides, it needs to be something that has all of these concerns in mind, and who's going to be the one to oversee it? Yes.
So am I kind of hearing that we already have
laws, policies in place that we don't need to add more of a, for lack of a better word, burden on the court system?
I'm not saying that you haven't, if that because you have certain laws in place that you shouldn't add more laws if they're deemed appropriate. If the legislature determines that this bill is going to provide safety for the individuals, if it's going to meet the policies that the legislature wants to go forward on, that is something the legislature certainly can enact. All I'm saying is that we should be aware that there is an impact on the courts from that action. But please don't hear me to say that if you think something is going to save lives and help people, that you shouldn't do it because there's a burden. No, you need to make that decision about whether to do it as a policy, but know that in order for us to implement your policy, the procedure is going to cost money and it's going to be court time. And so that should be something I think the legislature is aware of right up front so that it can move forward in a way that effectuates the policy in a way that you expect. What I think is a bad result is if a bill is introduced, a bill goes forward, it's signed into law, and this committee, for instance, has an expectation of what it's going to look like. And at the end of August, I get a call from a legislator saying, Judge Zone, I just heard about this judge doing X, Y, and Z, and that's not what we intended. What's going on? And I say, well, that's the natural consequence. And so I think it's important to make sure that your expectations of the policy and its implementation are ones that are fully informed. And you know the consequences of the decisions. In that way, you might be able to structure things in a way that is, if you will, more doable with less funding or less additional resources.
So just to follow up on that, because I didn't ask the question properly, we, in our existing laws, I mean, sure, we can always tweak something and make things better, but are we already covering enough of this to do what more this law intends to do, or this bill intends to do?
The law currently provides under 15 VSA section 665 small a that it talks about parent-child contact in the domestic violence context. And so the court does have flexibility there in the domestic docket to make certain orders, including under subsection 3, I believe, an order that says someone has to take one of these programs. So if there's children involved, and I do note that the bill to amend H222 does talk about adding in a specific clause for 665A that says in accordance with. And so you bring that in, and that would give us the mechanism to do that as far as parent-child contact orders. The question as to whether or not you need to add that in as far as other cases, or you need it as an additional component here, that really is one of policy, because it does capture an aspect of domestic violence that has been identified as one that may be helpful. And that is, if you have a number of people who might not be in the criminals program, in the criminal arena, and not go to probation, if they go through treatment, if they go through programs, a DP program, is that something that may benefit them, thereby benefiting the survivor and thereby benefiting society? Well, if you conclude that, then that's the reason you may want to impose something as a policy, as an option for the courts. It is an option. It's not a requirement that the court would do it, but having an option without a clear and unmistakable procedure as to what it's going to look like brings with it the potential to lose respect for the order and the courts. If people don't understand what the consequences are or how it's going to be done, if there's any concerns. And that goes on both sides. If the survivor believes that we have this order in place, the judge says this and nothing's happening, the survivors may certainly lose confidence in the ability of the court to follow through on its orders and provide the protection that the survivor may need. By the same token, if the defendant If nothing ever happens, that's has a negative impact on the defendant. Or if or if things happen that don't flow naturally or from a way that is expected, that can also have defendants get frustrated and not follow the orders. And our goal, when we issue an order, is protection of the survivor, and it doesn't happen again. And that the person gets the tools the defendant gets the tools to make sure that they don't go near the survivor and don't engage in those behaviors. So when we look at ordering, because if you put this into statute and you have a procedure, the next question is, well, will judges order it? The one concern that I have heard expressed is that if this is a potential, that again, you may see a situation where what are now default orders being entered, someone might say, well, I'm showing up because I heard somebody I know got stuck doing this program and they didn't go to the hearing and I didn't expect that. So I don't want that to happen. So you might actually have that impact of more hearings. But the question for the courts is exactly what is the program and is it appropriate for this particular offender? I think the testimony yesterday, as I understood it, was that there are different nuances in different counties of the programs. Not all programs are the same. What I was hearing is that one size does not always fit all. And so how does a judge know in their particular county what the size is and does it fit this particular offender, this particular defendant, in order to responsibly impose this condition? We don't want to impose a condition on someone that could be a crime that's actually not going to help them and could have the potential of having a negative impact on their behaviors. I also note that the council, and I saw this language on the council's website, it says, though intimate partner violence can impact anyone, women and particularly people of color, LGBTQ individuals, and other underserved groups experience intimate partner violence in specific ways and face unique challenges and barriers to resources. Vermonters in need of domestic violence accountability programming should be able to access services that are culturally responsive, inclusive, affirming, anti-oppressive, and rooted in their community and cultural values. If we have a defendant in court in front of us who comes from one of these communities, how do we know that the program we're telling them that they have to take or telling them to take as a program is one that meets those goals and honors what the DV community recognizes is an important aspect for those individuals? Is it the right program for this person? Is it culturally insensitive to this individual? And so a judge would want to know that information. You learn that information in the criminal context because the probation department, when the judge orders a counseling recommendation, generally the condition says you must have a screening for the issues that are marked. You must complete the screening by the date established by your probation officer. If it recommends counseling or treatment is needed, including residential treatment, you must complete the counseling or treatment as directed. You must attend and comply with the counseling or treatment requirements and satisfy those requirements. And one such requirement could be a domestic violence, it says batterer's intervention or approved equivalent. In other words, DOC makes that decision as to which program someone goes to. Here, who would make that decision? Is there someone or an entity that would be able to say, this program's not right for this particular defendant in this county, and they would need to go somewhere else? Because if our goal is to address behaviors, we want to maximize the effectiveness of the program. And so judges would want to hear, well, where do I send this person? As opposed to just saying it's a program approved. And who helps the individuals go and find the program? That's not the court's roles. And so if the judge imposes this condition, what happens next when the person walks out with that order? What's the procedure for them to understand where do they go and what are their options? That's important also. And what if you have someone who's a defendant from out of state and the court says, I think this program is necessary. Do they have to come back to Vermont for the program, or does the DV Council have programs that are approved in other jurisdictions? We see that with Crash. We have an approved program in Vermont, but there are approvals from other jurisdictions that can work. And so I point these issues out because it's important if we want judges to impose this condition for important reasons, that we have to give them the necessary tools to understand that they're doing it in the right case for the right reasons. and that it is supported, that the program is itself effective. As I mentioned earlier, and I think Ms. Holder said it yesterday, the orders are the victim survivor's order. It's their order. And so there is also the potential that if someone has an order and the judge imposes this, that the person comes in and says they want to dismiss the order and dismiss the case. And so what happens then? Well, does the order go away and there's no longer a requirement? Most likely, if the order is not there. Ideally, you would hope that someone who started the program would voluntarily want to continue it, which I think we would all say is a positive step towards accountability and safety. But I point that out because that's a component of the case too. What if the judge says, well, I don't want that to happen? We know that when a survivor comes in, it's their case. It doesn't work well for us to say, well, I know better than you and I'm not dismissing your case because this person needs to finish the program. Does that have the potential to further victimize them and make them feel as though they're not in control? And when the courts take over an order, does it send a message that people would say, I'm not going into the court. I wanted just X, Y, and Z, and the judge did all these other things, and it really has made my life more difficult. That can happen. And so we want to always guard on that. I understand that the program is free. If that is something that is an expectation, I would suggest actually adding that. If you decide to go with this policy, you should add that to the statute to make it very clear that at the program that at no cost to the defendant, so that it can't change. That what you understand you're going forward on today, that can't happen a year from now. Well, now they have to pay $1,200 like it used to be. And again, this is a policy decision, but if we're going to do it, let's do it right. Let's make sure we have a system in place that we can accommodate and that everyone knows provides real accountability. Having a system that does not provide the accountability and the compliance is just a system that I would again suggest brings with it the potential for people to lose respect and minimize the effectiveness of the orders that we issue every day. Because if someone comes into court, and we see it oftentimes, the one example someone recently said to me was, I always show up to try to get more child support and nothing ever happens. If people feel that's what's happening in the courts, we lose the effectiveness of these orders, and these orders are important. The conditions need to mean something and they need to be enforced. So any questions on that aspect?
I have one. So this is set up for not to cost anything, but it sounds like there is a pretty high level of cost that's going to be a cost and a burden that's going to be added to, and I'm going to use the word toolbox. It sounds like, again, I'll go back to it. It sounds like the toolbox is fairly well loaded already in this situation.
The toolbox is certainly getting heavier. But the question is the new tool that you're offering one that has a different aspect to it than the other tools that are here? And I think the answer is yes. It is a different tool. The difference also is that it's a shift from, we'll say, that prohibition, protective immediacy to rehabilitation. And so if you're going in that direction, yes, open the toolbox and put another tool in if that's a tool that you believe is going to help effectuate that.
Could I take a tool out of the toolbox to loosen it up to help with this bill?
I would not recommend at this time taking anything out. I think I'm a believer that if the toolbox gets heavier, lift with your legs and not your back. So we as judges, I think the more tools we have, the better we can address individual situations that come before us in the courts.
Thank you. Anyone else? Oh, sorry.
Go.
Did you want to take over?
Yeah, I do.
It's kind of a procedural question. Does the chair shift to the chair when you come in?
Keep on, you keep going.
I think I'm making him wicked nervous and I'm lost.
No, you keep going.
Anyone else?
You run this.
Hi.
Ian?
Thank you very much, Judge. Two questions. One, where is the debt? I don't actually know exactly what you read from, but like the purpose of an RFA that early, where is that from?
Rat v. Dimino, 162 Vermont, 1, page 4.
Thank you. And then, as I've been getting my bearings on this bill, I think you articulated like a feeling that I've been having, which is this policy decision around expanding sort of the purpose of an RFA, or like I'm not trying to put words in your mouth, but my understanding of your testimony kind of, this immediate response to protect people versus rehabilitation and additional steps. Based on who you've spoken with, and I think what I understood from your testimony, am I right to say that if we implemented now with this expansion, that it could impact the court's ability to utilize RFAs in the immediate sort of response role moving forward?
What it would do is it would, at some point, we have to check compliance. We have to see what's going on. So we would have cases coming in, and unless there's a procedure, and unless there's someone giving us what's happening, what do we do? We have no process for addressing. We sent you out the door and told you to do something. In the criminal context, we know what happens if you don't do it. DOC files a violation of probation, you come to court, here's the standard. If you haven't done it, you can be violated, and here's what happens. Here, if you haven't done it, it's a crime. So, is there a simple process? Maybe the Attorney General gets involved and sets up a unit that goes across the state and checks compliance. And then they can bring charges, they can bring a case. But then you have the complicating factor of, well, okay, are they bringing it really within this case? Because they're not a party to the civil case. So they would have to have some kind of statute that says that they can bring a contempt hearing, even though really it's not their case. Or they can that you have to provide notice to them so that they can follow up and file a criminal charge. It can get complicated.
And then just one other question. Thank you, Mr. Chair. Is my Fifth Amendment concern there, or is that my sort of?
What's your concern?
Just that basically when you got somebody in the criminal, I've just explained it a couple times, so I didn't want to have to, in case you had heard it in the testimony before. Just if you have somebody in the criminal docket and they also have an RFA and they get this order and they need to go through DVAP, and depending on how the DVAP is run, if they were to have to talk about the case, or they could incriminate themselves, that would be a concern on a Fifth Amendment.
I don't, certainly if that's a requirement of treatment of the programming, there would be a Fifth Amendment concern. I don't know what the confidentiality requirements are, the specific provisions of the treatment.
And so if we were to, for that particular issue, if we were to sort of build in a confidentiality structure, that could sort of protect against that.
You probably want to hear the Attorney General speak to that, or the state's attorneys, because I think that they may have concerns anytime you build in what it could be effectively confidentiality or immunity, you may have unintended consequences. What if something is said that should be known and should be acted upon? Then there could be concerns that you have basically given someone a free pass on something that they shouldn't have had a free pass on. So I would ask law enforcement side to weigh in on that.
Okay, thank you.
Angela?
Oh, look at that. Super. Thank you so much for this, Judge Johnny. I hear you. That makes a lot of sense to me, what you're saying about how this becomes like an outlier in the list. If we're looking at the list of potential additions, or things that can be included in an RFA, and that it is a policy shift. Effectively. And I agree that if we're going to make that policy shift, if we decide together that that's what we're going to do, we want to do it correctly. I've been taking notes, but I'm sure I've missed some things. Could you provide us with a written, maybe you've already submitted written testimony, but I'm looking for a list of things, if it can be that simple, of what we would need to add procedurally, because I do think this is an important policy shift. And more importantly, I guess the Domestic Violence Fatality Review Commission feels that it's an important addition. So I would love to see a written version of your concerns if that's possible. And I'm wondering, you mentioned that there's no process for compliance checks. What is the process now for all of the things that can be written into an RFA? How do we check compliance on those?
Law enforcement, crime.
Okay,
Or if, let's say there's a financial obligation or an exchange of personal property or something under it, the parties to the action can file something with the court and bring it to the court and say, the other side is not following this.
okay,
The court does not bring cases back in and say, we're
Right.
going to follow up on these orders. That's not our role.
right. So how would the existing compliance check system or procedure fail us here?
The plaintiff, the survivor would have to file something and say they have violated this order, in which case they could come to court. And the court would say, have you done it? In which case, before the court would ask that question, I would say, do you understand that violation of relief from abuse order is a crime under state of Vermont? You understand that because the court is going to be asking you questions concerning a crime in this case, or the plaintiff may be asking you questions concerning a crime in this case, you have a Fifth Amendment right to remain silent. Anything you say can and will be used against you potentially in a court of law. Having that in mind, do you wish to go forward or do you wish to consult with counsel before we take any steps? I would suspect, as we oftentimes see, a lot of individuals will say, I'd like to speak to an attorney. So then the question is, okay, if they're about to speak to an attorney, do we have to get them one? And so then we see if we can get them an attorney. And then we move ahead and the attorney says potentially they're not going to talk about it. And then we look at the plaintiff and say, well, they haven't talked about it. They haven't provided us proof of anything here. And you can contact law enforcement if you believe there's a violation of the order. We could, again, take contempt steps, but if the person's taking the Fifth Amendment, invoking that, it's difficult for us to require them to say anything.
So then it sounds like the addition of this programming option to the RFA statute wouldn't actually change. It doesn't sound like it's a unique element in that you would need a whole new an attorney division of the AG's office or something to follow compliance because it could be handled in the same exact way that already exists.
If the position is that the court is going to treat this the same as every other component of an order, and you're going to leave it solely on the shoulders of the victims, you are correct. We do not need anything different, which means the victim would have to be the one to come in to prove the noncompliance and take the steps to do that. Self-represented individuals might not have the capacity to do that. And so if you're seeking to have a provision that has teeth and is going to really be meaningful to make sure that someone follows it and that they understand that and doesn't, if you will, put the survivor on the seat to say, boy, Bob hasn't done this program and I know that, but I'm afraid that if he doesn't, that if I report this or I do something, he's going to be charged with a crime. If you're putting them on that seat, that's probably not a place they want to be.
So are you saying we should possibly consider amending the RFA statute to provide more teeth, generally speaking?
No, I think that for the other violations, they report it. And they say the survivor has the ability to go to court and say, I want a judge, they're not following this. But as far as if they're seeking contempt, you generally don't see someone saying, well, I want a contempt order and a relief from abuse because they contacted me. You generally see them call the state's attorney and say, charge them. And so what I'm saying here is that they can say that, state's attorney charged them, they haven't completed this program, or they can say, well, I don't want them to be charged, I just want you to tell them to do it. So no, I don't think that you need to be amending the RFA statutes for more teeth because you have the ultimate teeth, and that is law enforcement can go and arrest somebody if they have evidence of probable cause to believe that they violated it.
Okay.
Good.
I guess.
Just one more thing to include on that is we detect violations all the time without a report. Oftentimes
You detect, did you say?
we detect violations of restraining orders or really from abuse orders all the time without any report because we know the people or we stop one and we're talking to them and realize the other party is there. So that's a very common circumstance.
And you have and generally you have a law enforcement officer in court. So if the person comes in and says, Representative Oliver standing in court and hears somebody giving, they go, yeah, I violated the order. There you go. He can go and take action on it.
Yeah, I'm just struggling to understand how this is different then.
It's not different if you're not expecting the court to have compliance checks or take any affirmative action.
Okay.
If you are asking the court to sit back and wait for something to come to us, it's not necessarily different.
Right. And I think what is different between my perspective and yours is that obviously yours is much more well-informed. And you're thinking of, you've mentioned a couple of times the sort of comparison of the DOC programming that is supervised or compliance checked by DOC. And so it's lacking that element. It's similar because it's programming, but it's lacking that follow through element.
If we say to someone, go do this, and they don't do it, and the order expires and nothing happens, what have we gained? And that's the question that some may say, well, we put that order there. And the other question that some may ask is, what have we lost? We now have someone who blew off an order that was important, and they've lost respect. And so if the legislature wants to say, we're prepared to enter this, the court can do it. We recognize there's no compliance checks that are going to be coming. We recognize that there may be no accountability for someone who doesn't follow the program. That's a legislative policy decision.
Haven't we already made that decision with the existing RFA statute?
No, because the provisions in the existing RFA statute generally are talking about prohibitions which can be observed by other individuals for violations of the law. And it doesn't require a programming or a third party. If Representative Oliver is standing in court and sees two people who aren't supposed to have contact, he doesn't need to go to the treatment provider to find out if somebody completed it. He knows that's a violation. Law enforcement officer witnessed it. Law enforcement officer cannot witness a violation of this provision. They have to research, they have to investigate to find out if it's been violated.
Are most violations of RFAs witnessed?
By one of the parties generally. The plaintiff would often, right.
So
I consider them a witness.
yeah, and they would be the witness to this.
They wouldn't be the witness because they wouldn't know what the person's done in the program. They are not in the program to know whether the person has completed it. They'd have to bring a witness to court to say, this person has or hasn't completed it. And that's the difference.
Good. Yeah. I think on that, we heard some testimony that the court can order things outside of the sort of listed ones.
Absolutely. The court can order such orders as may be necessary to prevent abuse.
And do they, in practice, are they ordering things that are outside of the listed ones in 1103?
Does it happen? Yes. If there's a specific need in a case?
Okay.
Yes.
Yeah.
But that again gets to the specific case and whether or not something is necessary for this victim in this case to be able to get the protection that they need. But yes, courts will order things. In fact, that was before you came into the legislature, but there was a question on this very point before the legislature amended the statute to make it clear under 1103 that the courts could 1104 that the courts could order the seizure of firearms for a temporary order. Mm-hmm. There were judges who took that position that we had the authority to do that, even though it didn't expressly say it. And so the addition of that statute was one that I believe I testified really clarified what most judges were doing anyway.
With one follow-up, do you see any conditions outside of the listed ones that have this sort of concern around how it's reported a violation? So like programming or something that's not as explicit as like a no contact or not within 300 feet or something like that?
I can't think of any right now. The one place that this kind of condition comes up for treatment and programs is in, I referenced 665A for the DV section on the domestic docket. Courts will order that someone has to take this program. And in that case, we can say you have to provide proof to the court, or the plaintiff has to bring it, but that's not a crime. That's a different circumstance. The remedy is already there. If you don't do what you're supposed to do, the consequence is you're not going to see your children, or X or Y. Not a crime, but it is clearly spelled out what the requirement is, what you have to do to meet it, and what happens if you don't.
Anyone else? You want to go to the amendment?
Sure. 222 draft 1.1.
Sure.
Section 2. I want to make sure I understand what the intent is. The intent is to add a separate provision for course of conduct. Course of conduct means two or more occurrences, two or more acts. And what the intent of this new section is to say, we know that we set up here two or more acts, but we don't mean it for down here. We want to, something else means course of conduct, correct? Is that?
I would ask sponsor, am I a sponsor on this, Bill? Ask the lead sponsor. There it is. General Arsenal.
I would be happy to answer the question if we can repeat it. I'm not sure I understood.
It says, as used in subdivision A of this subdivision on line 18 of page 1, course of conduct includes use of any electronic. And so what I understand is that the legislation is to say that, well, course of conduct includes this.
Yes.
Well, okay. The problem with that is it can't really, as defined, it can't really include something if by its very terms, what you're including doesn't fit. In other words, conduct means two or more acts. One act or this continual act doesn't really seem to be so much of an inclusion as a separate clause. And the Supreme Court has ruled very clearly that a continuous act is not a course of conduct. So what you're essentially doing here is overruling that to these actions. And so what I would suggest you do is say, as used in this chapter, course of conduct means you put a colon in, and then you have a small I, two or more acts. And so you get that first clause as it currently stays. You just keep it right there. And then you say, a little or, and then you put the parenthesis with the two small i's, use of any electronic, digital, and you bring what you have now as subsection C. I would suggest bringing it up. So what you're saying is course of conduct can be two things. It's this, which requires two or more, or this, which doesn't require two or more. And then you can leave B as it is. But I would just suggest bringing it up like that.
Yes.
On page, now when you get into section 3 about use of electronic tracking of motor vehicles. Subsection 2 talks about, on page 18, C2, exceptions. The minor child of the parent or legal guardian. So we know that the intent is if it's your minor child.
What page are you on?
Page 4.
Did you mean line 18?
Line 18, sorry. I apologize. I'm sorry.
Had me confused.
Yeah. So what this says is basically, if you put it in there and it's to monitor your kids and they're minor, under 18, well, keep in mind that the legislature has also been very clear about treating other youth who are over 18 as delinquents and youthful offenders, recognizing that sometimes they might need guidance or some parent overseeing them. So if you have, for instance, a situation where you have a, let's say, 19-year-old who is engaging in delinquent behaviors and is before the court, and the parent says, you know what? I want to help out the DCF officer or DOC. I want to help out here, and I'm going to put this in there to see where Junior's going because I'm not sure when he says he's going somewhere good, he's going there. That parent, just so you know, has committed a crime under this new bill. And if that's your intent, you've effectuated it. Otherwise, they have to go up to Junior and say, Junior, I put this in your car, which gives the hint to Junior to do what? Ride with Bobby. And so again, I point that out because these are these potential consequences of having it restricted to that type of provision. Again, you might have somebody, an adult who's in treatment court and they're living with their parents. And the parents this might be a good mechanism for the parents to find out if they've been going to the wrong side of town. But again, that's a policy decision. I just point out that those are considerations you might want to have because there may be unintended consequences where a parent with the best of intentions may have stepped across the line. Subdivision 3 on page 5, line 7. It shall not be a violation if electronic tracking device is attached to stolen goods for the purpose of tracking them. What about if you put it in your box that you're sending via FedEx? It's not stolen, but you are tracking the product. Is that a violation? Or you have your luggage packed to go on a well-earned vacation for town meeting week. And instead of driving it, you're going to have it sent by a carrier. And you put your Apple AirTag in there. Is that a violation? Well, when you go back up ahead, it says, for purposes of monitoring the following, the operator or direct any other person to do so. You know, if I'm putting it in there, I want to know where the operator is going with my package. So I just point that out by the use of the word stolen. So you might want to look at that as a potential issue because there could be an unintended consequence of something like that coming in. On page 6, for use of the vehicle, it says shall grant the plaintiff possession of a vehicle there. I recommend the word should say may. I can give a lot of reasons for that, but the essence of it is the court has a lot of facts before it that the shall may lead to bigger problems than it fixes.
Anything else, sir?
That's all we have.
Anyone got anything else? Or with network? Next witness? Thank you, Judge.
Thank you.
Next up, Laura, please. Enjoy the chair and
I'm getting old.
identify who you are.
I'm enjoying this thoroughly. And let's make sure that, we'll hear and we'll make sure we hear with Berta that we have something to be paid.
Oh, my gosh. Oh, from now on, I'm to be referred to as chair.
Oh, sorry, Chair.
Oh, does witnesses?
Good morning.
Good morning.
Nice to see you.
It's nice to see you as well. Thank you for inviting me. I appreciate the opportunity. For those that don't know me, my name is Laura Byerly. I'm the director of the Victims' Rights Project at Vermont Legal Aid. Been a practitioner for 18 years, and I've been specifically at the RFA docket in Franklin County every Monday for the last 9 years. So I know RFAs. I'm also on the Family Rules Committee, so I also know RFA procedure fairly well. I represent victims of crime in criminal court, often victims of domestic assault, and I'm familiar with the conditions of release that attach to that. So I would welcome any questions that the committee may have on any of those roles. I've been representing survivors, as I said, for 18 years in various capacities. I've even represented them as defendants in RFAs. Survivors really do want this opportunity to ask for something that will help change the defendant's behavior. Almost every survivor that I have talked to is seeking restraining order, not to punish in any way, but to make sure it doesn't happen again and to make sure that their children are protected. And I've taken several of these cases up to the Supreme Court. So I'm very familiar with the jurisprudence on RFAs as well. And one thing that we will hear all the time is that this is a remedial statute. We're trying to help people here. We're trying to give people the tools necessary to change their behavior. And that's where I really see H222 when it comes to the DVAP programming coming into play, because we want to be able to ask for this. We want to know that we can ask for this, even if I'm not sitting with a survivor and I'm not on the after hours call and I'm not filling out the paperwork. They don't know if we include it as a possibility under and any other relief that the court finds is necessary to protect the plaintiff or their children or both. I don't see these ordered. I don't see these asked for. I honestly don't even offer this as something to ask for unless it's within the context of we're negotiating a stipulated order. So sometimes I do see them offered, ordered in a few cases where there's a stipulation. So we have seen that happen. I also have a lot of survivors who go to the DVAP programming, especially when that's been ordered on the criminal side, because they want to know what's happening. And so they're allowed to observe the program that their abuser is not attending. So they're not interfering with that relationship at all, but they're getting to understand this tool better. And that is often something that folks are interested in. I'm also on the Franklin County Domestic Violence Task Force, Franklin Granite O'Connor, and we also have the DVAP provider there who comes to those meetings and helps make those connections for people. And as I said, I'm in court every week, and I know that the network is in court every week. So if there are concerns about getting information of these programs to the judges and to the litigants, we have folks on the ground who can do that. Like, just as I'm always giving people information about how to connect with supervised visitation centers, those tools are available. So, I'm happy to answer any questions. I'm happy to talk any of this out, but I just wanted you all to know that we do support this as an important tool for survivors.
You have any questions?
Me?
You
go ahead. Yes. So I didn't take the full detail of the notes of what Judge Zonay shared as kind of concerns and pieces. I'm wondering if you can speak to any of those. I feel like I'm hearing there's support for it from your office, from the network, from the AGO, and I'm also hearing the judgment. Okay, well, there's a lot of details that would be needed. And so do you agree? Or you're like, actually, I think it would be fine just how it is. Because I feel like there's that piece that he brought up of like, there wouldn't be compliance check and okay, from your perspective, or you're like, actually, we would need to add and flesh that out a little bit. If you can just speak to that, that'd be helpful.
Sure, happy to. We don't compliance check on the 300-foot restriction. We don't compliance check on the texting provision. We don't compliance check on the no contact orders. We don't compliance check to make sure they're going to the supervised visitation center when it's ordered. So I really don't see it as a problem. And we also don't necessarily prosecute when those violations happen either and are reported. We don't necessarily, I know a lot of survivors have reported what have been referred to as technical violations, and they don't end up resulting in criminal charges. In a lot of ways, this is just giving people the tools. And I think what I would love to see happen here is that this really changes behavior, right? I would like people to take advantage of this opportunity to learn to do something else and not abuse their partners and their children. Where I think it can also be valuable, even if they're not complying with it, we're going to have additional custody hearings then. going forward and visitation hearings. And we're going to have, just as Judge Zone mentioned, 665 little a, it's a little confusing, by the way. It's but we're going to have more hearings. And I think that having the judges know, hey, this was ordered, did you go? In that context is a powerful statement about what's going on with this family. Just because the tool's in the toolbox, also we're giving judges the discretion to order it or not. And I think we need to trust our judges to know when it's appropriate to be ordered. I mean, I certainly don't want to see this ordered in a roommate situation or in the pure household member situation that comes up. But I think that this is an important tool if the goal is to truly be remedial and to fix the behavior and frankly put me out of a job, which I would love. I can go back to suing banks. It's okay. Then I think we need these tools. And I think we need the public to know that these tools are accessible and that they can attend them. And maybe people who've never learned that there's any other way to treat people can learn why they do it and maybe not do it anymore. So I don't have as many concerns because we don't see the courts inundated now with cases about enforcing relief from abuse orders. He's given me some ideas on how I might want to go about doing that. But generally, if the survivor has a concern and wants to bring it back, they can. And I also see this as an important tool in the toolbox in the cases where a survivor may not want the stay away or may not want the no contact, just wants the abuse to stop. So we use a shorthand, a no abuse order or a no harass, no stalk order. So how about we give somebody the option or the tool to learn how to do something else? So I really do see this as less of a burden on the courts and more as a tool that might eventually decrease the burdens on the courts.
If I can follow up, Chair. Thank you for that. And I would agree, like the learning piece, the programming, all for that. And I think but I'm hearing the enforcement piece or compliance piece will be a gap. And so I'm just trying to see, like from the victim survivor perspective, that there would need to be there's not going to be any compliance. So but what feel like I'm hearing is just knowing that that is being put out there. That's a step. And is that what I'm hearing? Because I feel like that could be really frustrating, disappointing. Be like, hello, that was part of the RFA, and they're not doing anything about that.
And I can see that being a real frustration, definitely. It's always a frustration when an RFA is issued and you work really hard to get a restraining order and then it's not followed, but then it's also not enforced. But another way to look at it is survivors' behavior as well. It's saying we're giving this former partner or current partner every tool and they're not taking it. So maybe from the survivor's perspective, this is one more thing to show that, well, maybe you need to, your behavior in allowing them back in needs to change. Maybe this is something that's empowering them to say, okay, they're really not committed to changing that behavior. And so I need to look at ways of getting out. So it's just an added tool for them. I would love to see maybe a way of having compliance. Maybe the compliance issue is that if a person has not completed the programming within the restraining order time, it's extended for another year to allow completion of the programming or something like that. But I really think it's more of a powerful tool for helping to encourage a change in behavior. And we wanted that to happen before we end up in the criminal context.
I know the defendants really well. You know the victims and survivors really well. I really know the defendants. I've been dealing with them for over 40 years as a police officer. And I've spent a lot of time in the courtrooms as well as a sheriff. My concern, and I've asked a couple of people already this question that I would suspect could violate something like this. Their immediate reaction is, well, what do I get out of it if I complete it. Because they see it as punitive.
Mhm.
And I'm saying, well, that's not the thing. Personally, the difference in society is it's like, if I did something wrong, I am going to throw myself off the sword. And I'm going to do what I need to do to better myself and just to make amends with myself and my family or whatever. Right? A lot of these folks don't see it that way, and they're going to test the system. And if you mandate something, and it sounds like you're going to take their time, it feels like a sentence to them. I'm wondering, like you just said, if they complete it, or if they don't complete it, then maybe the order could get extended. If they do complete it, maybe the judge could say, well, we can revisit visitation and I will take what you have to say with more value, or you follow?
Right.
Instead of, I don't know how we're going to. That's the logistical part. Unless the people teaching it make us aware while they're not showing up. Now, is the instructor, do you want the instructor to have that kind of relationship with the people that are taking the course? You know, that's, you know, I don't know. I understand what you're saying. Has anybody even before this point made it available to say to the court, well, here's a pamphlet you can give out with every one of these restraining orders? You know,
Maybe we should.
well, you're right. You know, you don't see much as far as advertising and marketing of something, if you want to call it that, but that's what it is. I mean, for someone to get help. I'm just really suspicious about how this will pan out for the courts. If we make it
Yeah.
a mandated thing for them.
Well, I've seen it mandated on the criminal side,
Yeah.
certainly. I've also seen defendants choose to max out instead of attending, or choose to take an all jail sentence, an all to serve sentence instead of attending program. So for those folks who aren't going to comply, I'm not sure that we're going to get them to comply within the RFA system or within the criminal court system beyond sending them to jail when they violate.
They can't do anything wrong
Yeah, yeah, because there's no violations in that. Sorry, Elf.
Well, not physical, I mean, but.
Yeah, no, I guess what I see this reaching are the people who need the programming the most, which are the ones who don't know how to do anything different, right? They've never seen behavior modeled. And this is more of an opportunity necessarily than it should be considered a punishment. And I think it's
but that's how they're gonna feel, from what I would
okay.
take is.
Right. Well, I think the carrot and
that's just my example. If there's, you know, the stick and the carrot, that's different.
well, maybe the carrot is then that they could move to modify the RFA to shorten it, saying they've completed the programming. I mean, they have access to the same systems, and so they have access to seeing their children more, or seeing, you know, or having that relationship that they broke. So maybe the carrot is more in repairing the things that they should be caring about. I mean, we're talking about intimate partner violence.
I mean, a lot of people don't have the motivation to go, even with telling them, if you come back to court in a little while after you've been doing this, maybe we can change something. They don't do that for themselves. I mean, some do maybe, but not all.
But I guess I don't see that as a reason not to offer the opportunity.
Oh, I'm not saying don't offer the opportunity.
Yeah. We're not going to reach everybody, but if we could reach, especially if we're talking about, I would love to go to court and not recognize any of the defendants.
Yeah,
A whole new set of defendants, what an amazing thing that would be. And a whole new set of plaintiffs, what an amazing thing that would be. And how about fewer of them on both sides? I think there are a lot of components that go into domestic violence and changing that behavior. We got to try what we've got. These are the tools we've got, so let's give it a try.
But
But we have so many of those tools that are out there. You're already working as many different lanes as you possibly can to try not to see that person again, yet you're still seeing them. So how's this bill, what am I missing? How's this bill gonna help? Like, I think what Tom was saying, actually have somebody go and do something, make a difference in their life, turn their life around.
Well, they haven't been trying this so far.
So how's this bill gonna do?
So if this is going to get people to use this program and attend these programs and learn new behavior, then that might make the change. We don't know yet because we haven't seen this program in that context this early of an intervention before. We're just talking punitive. We're just talking jail time. We're just talking probation. We're just talking furlough. This is an opportunity to do the work so you don't end up in jail and with furlough and with DOC supervision. This is without getting to that point where they've seen their family members going. I mean, this is generational behavior that is taught and learned. Maybe this is an opportunity here to say it's time to unlearn that behavior. There are other ways to communicate your frustrations and your anger without resorting to control and violence towards your most beloved people in your life.
That's exactly what the RFA does.
But does it? It just says you have to stay
Well, it
300
doesn't
feet
necessarily
away.
teach them, but it adds that protection, which is what the statute says. When it's showing an RFA, that it has to be a quick remedial way to stop the abuse.
Right.
And the consequence of that is if you violate it, you go to jail.
Mhm.
Now, if you add a condition to that that says you have to do this programming, you're adding another condition that's probably going to try to send them to jail. Although, how long can you keep them there? We already went over that whole thing, either civilly or criminally. That's a kind of a nightmare. So I started with domestic abuse before you had to even arrest anybody. That's how far back it went. And when mandatory arrest came in, that was like life changing for domestic abuse. That was just an amazing thing that came in. You know, when we started arresting people that were abusers, it really cut way back. The number of calls diminished very rapidly after that, except for your few, you know, that it was a learned, I don't know, genetic behavior. I don't know. And then the restraining orders came in. And on top of that, and it was even better. And I would hope to think that this could do that too. But I have a funny mental roadblock with that. I'm not with it yet, I guess.
I interned in a prosecution office in Maryland and DC, and DC was a mandatory arrest jurisdiction. And I saw how that played out. And I saw it in a transition time. So it became very.
How long ago?
20 years ago.
Yeah. Ours was even further back.
Mhm. And I've watched the development of it. I think
Was it effective?
Unfortunately, what we found was that women fight dirty. And so they were being arrested in domestic violence situations because women scratch. And so they're scratch. So the women were being arrested because they caused the bleeding and the bruises come out later. So there's nuances and dynamics to this whole problem. And I think, again, we come back to how are we going to teach people to behave differently? And how are we going to intervene in a way that gives them those tools? And I keep coming back to the fact that we've got to try. We've got to try to give them the opportunity to change that behavior before we start purely talking about punishment. Well, we already have the capacity in those programs. We have the ability to give them that opportunity. I don't think there's enough knowledge that this is available. I certainly in Franklin, Grand Isle, Chittenden, Addison, and those are my main counties for RFAs. I have never seen this ordered in an RFA context. I'd like to give it a try.
do you think we're holding people accountable enough for their actions and giving them enough tools for them to change? First of all, that's two questions. Are we holding people accountable enough? Number one.
Well, the RFA context isn't where we're going to hold people accountable. And the criminal context is. So I don't know. I think we need to look at that. I think we have to do the two things simultaneously. If we're going to hold people accountable, we also have to give them the ability to change their behavior, because we can't just keep throwing punishments at people.
Went right into my next question. Aren't we already, by leaps and bounds, for lack of better words, aren't we giving them already many options, many opportunities to change and turn their lives around and give them second chances, third chances?
We haven't this early. So this bill allows maybe an earlier intervention, maybe an earlier opportunity to make that change. Maybe it's too late when we're telling them they have to do it as a condition of probation, and when we tell them that they have to do it as part of a restraining order, that might be the time to intervene instead of waiting.
You done? Yeah. Well, that's my fear too, is, when we have, the survivor going to get an order, it's their statement, without anything else, so there's no real law enforcement investigation or anything to mandate this. That's where I start to lose. We're requiring to do something that we don't even know if the truth is coming. I mean, I've seen a woman abuse her. You mentioned that sometimes they get, blamed for it, but I have actually seen it happen looking through the window. And I have to suspect too that sometimes women lie. I know men do. I would assume some women do too. So, and you're going to require this, suppose the person did not do this. I mean, so what? And it's bad enough that we have to make them separate, and the whole 9 yards to keep her safe, or hide somebody, give them the house, the car, custody, whatever it may be. We have to do that to keep somebody safe. But if we, because of a restraining order, require someone to potentially interrupt their work schedules or whatever it may be, or jeopardize going to jail until it's been vetted in a criminal court, that's fine.
Just
Is there a question there?
yeah.
Yeah, I guess. I mean, well, she was starting to answer.
Disagree.
Well, no, I guess.
I've represented men in restraining orders. I'm not gender specific to abuse.
No, I know.
Yeah, so I guess that wasn't a question, so I guess I'll see what the.
Just very quickly, because we're cutting into lunchtime here for these important people. The amendment, anything you add on the amendment?
On the, for the electronic monitoring of vehicle?
Anything?
Okay, I would second Judge Zone's change in 1111 to make it may and not shall. I certainly do see this happening more and more. And I think we need to figure out some way to address it. So that would be the only major edit that I can think of at the top of my head.
Very briefly, because we're running.
Sorry about that.
Really, no. Thank you so much for your testimony. It's really helpful for us to hear from practitioners. Two questions. One, beyond the electronic monitoring, the last section is the use of a vehicle in an RFA order. Do you have any thoughts on that subsection or section?
Right.
Just from it's my understanding right now is that this currently you could order a vehicle, but the language isn't explicit. And so I'm just curious, the way we've made it explicit, do you see it working with how things are going towards now?
I think it's useful to make it explicit that that can happen. It's similar to the way awarding possession of a home can be explicitly ordered in an RFA. I think it needs a little tweak to change that shall to a may.
Yep.
But I do think it is useful and it's becoming more and more necessary in the RFA context.
And then just the last question, how many of the RFAs that you are involved with have a parallel criminal?
Maybe 10%.
Okay, oh, it's much lower. Thank you.
Sure.
Okay, well, thank you. I don't think we're done with this, Bill, so we might be having you back.
I
may not be the chair at that time, but.
May not.
I'm happy to come back whenever.
Might have more questions if he's just the chair.